Now a decade since the Rome Statute came into force, leading to the creation of the International Criminal Court, designed to deal with war crimes and crimes against humanity to ensure that justice prevails. Uganda was one of the first countries to ratify the statute and one of the first to have a situation referred to the court, leading to the indictment of the ELRA's top commanders. Uganda has also been able to domesticate the Rome Statute of the International Criminal Court by enacting the International Criminal Court Act 2010, which is now part of Ugandan law. Despite these huge successes, all the arrest warrants in the Ugandan situation are still outstanding. Victim communities who expected justice have not been able to receive it for many years. This has created gaps with inactivity on the ground and victim needs in form of psychosocial, medical, and legal and reparations increasing by the day. The court recently completed the first trial with the conviction of Thomas Lubanga, a former warlord in the Congo, and other investigations are ongoing in the DRC, the Central African Republic, Ivory Coast, Kenya, Libya, and the Sudan. At the African continent level, there is growing perception that the court is targeting Africans, and the African Union has resolved that African states should not cooperate with the court following the arrest warrant issued against their colleague, Sudanese President Omar al-Bashir. In fact, the African leaders are proposing to put in place an independent African court to deal with crimes against humanity. Now, as this institution makes 10 years of operation, it is very important that an assessment is made of the court's achievements and progress for the last decade and make recommendations for the court's future work. So on Spectrum, tonight assessing the international criminal justice system, is the International Court meeting its expectations after all this time? Our guest tonight, Mr. Tumwesigye, Legal Associate on International and Traditional Justice Program at HURINET. You're most welcome, Mr. Tumwesigye.
Thank you very much. Good evening, listeners.
We're also joined by Mr. Bwesigye, expert on international law and justice. You're most welcome, Mr. Bwesigye.
Thank you, Edmond.
And Mr. Jimmy Otim, Public Information and Outreach Officer of the ICC in Uganda. You're most welcome, Mr. Otim.
Thank you and good evening, listeners.
Mr. Otim, can you give us a synopsis of how the first 10 years of the ICC have been?
Thank you, listeners out there. Edmond, thank you too. Today marks the 10 years of the existence of the ICC. As some of us might know, 10 years ago, the international community made a milestone towards the end to impunity, where on the 17th of July 2008, 120 states and other intergovernmental organizations, including civil society, convened in Rome and adopted the Rome Statute and made a commitment to the fight against global justice to end impunity. Today, the court is supported by 121 states. The court has about 20 arrest warrants issued. The court has 18 cases before the court, and the court is monitoring situation in 7 situations in different continents with 7 ongoing investigations in 7 situations. This is where the court is at the moment. And of course, like you mentioned, one convict is already before the court, convicted, Thomas Lubanga, in the DRC situation. But the court is active. The court needs support from different stakeholders, civil society, political leaders, religious leaders, international community, so that the fight against impunity is a collective effort and impunity is fought.
Do we need an African court, an African criminal court?
Well, I can speak about the ICC. I'm not the spokesperson of the African Union. But as we know, the International Criminal Court is not like the omega of this world. We know that the Rome Statute provides that the International Criminal Court is a court of last resort. It plays a complementary court. We would not even need the ICC in the first place if national courts were doing their work. Remember, the ICC only comes in if a country or a state is unwilling or unable to prosecute the alleged crime. Otherwise, it is the primary responsibility of the individual countries to prosecute and investigate the alleged crime. ICC is a court of last resort. So the discussion here going in Africa in different corners is a healthy one. The only thing is the practicality. What is the intention of this? Is it meant to shield away? Is it meant to cover, individual or something like that? But otherwise, as the court, the fight against impunity is a collective responsibility.
Stephen, what's your view of the ICC's performance in the 10 years that have gone by?
2 or 3 things, maybe to add to what Jimmy has said. I think that the assessment of the court must take into consideration the fact that the 10 years have been formative years. And in making an institution, you don't judge an institution in the first 10 years. Nonetheless, I think that we need to make an assessment. The court has had one conviction, has 7 investigations in 7 countries, and others that are ongoing. That for me is very, very important. The court has indicted the first president, the first sitting president, who is now isolated in most of the countries in the world. That for me is very, very important.
Bashir of Sudan.
Bashir of Sudan. And sends a very huge signal to everyone who thinks that they are safe even when they are committing crimes. So I think that for me, that should be the assessment of the court. But taking in mind that the formative years have been these 10 years, there could have been very huge mistakes. But the court has made a huge stand in the fight against impunity.
Do you expect it to move faster in the next 10 years for that matter?
Well, I mean, to say that the court should move faster is to forget the ideals of justice. Justice rushed sometimes is justice crushed. And to argue that the court should then have a conviction in the first 2 years is in my opinion, to forget that every trial at the court, for instance, takes more than 2 or 3 years. There are questions of evidence, there are questions of witnesses, who are probably more than 1,000 in every trial. And therefore, it's not going to be faster.
Right.
It won't bring about that instantaneous gratification.
Okay.
Yeah.
So it's a large wheel that turns slowly.
Yes, it's the large wheel that turns, so like you said. Yes.
Brian, talk to us about your own assessment. How has the ICC performed in the 10 years that have passed?
For me, the ICC, just like the ICTR or the ICTY, the International Justice Framework, is still the same. You have an expensive procedure withdrawn from the victims, that does not necessarily serve the interests of the people that it claims to serve, because we are looking at 10 years and we're looking at billions and billions of money spent, and we're looking at victims that sometimes have even said they do not even care whether these people are taken to the court or not. You have, let's talk about DRC, because Lubanga was convicted. In Uganda, if someone is going to undergo trial for more than 5 years, everyone is going to cry that the justice system is corrupt and all that. How many years has the Lubanga case taken? To the extent that the incompetence of the prosecutor actually at one stage led to the trial chamber saying that Lubanga should be released. Now, is this a system that we should call a court of last resort? It might be the one that we have right now, but is it necessarily the best? We know of the conflicts in the Congo. We know that this was an ongoing conflict. And even right now, we know of people who are saying that Lubanga was not supposed to be convicted. We know the evidence that could have even implicated Uganda and Rwanda that the prosecutor sat on.
Uganda could also...
Yeah, because Uganda, the ICJ decision is clear that Uganda was complicit in the crimes that were being committed by Lubanga. But because Museveni is cooperating with the prosecutor, then you don't have Museveni indicted. So is this really justice? If we are talking about justice, is this really justice? Or is this a court? Or
well,
this
but justice exists in a context. You don't just go around harassing everyone.
Then that's not justice. If you're talking about justice, there is that Latin principle that do justice and let the heavens fall. That is what the ICC promises.
So it's a pedantic thing. You do it the way it is supposed, according to the letter. Forget about the spirit.
Yeah, but then that means the ICC promises more than it delivers.
Stephen, help us on that.
I think I'd probably, with respect, I would like to disagree with my old friend, Brian Bwesigye. The fact that...
but you have a brilliant argument.
Very brilliant argument. And the fact that probably it's a very, very valid argument. The court has probably spent more than €500 million and had one conviction. It's a valid point. But when you look at the fact that, for instance, the national systems in the Congo are broken down, and probably victims of the crimes that Lubanga committed in the Congo would never have seen justice, not one day. But the fact that, for instance, today they can go and address the court for reparations, and they can participate in a system that allows them to bring their witnesses, to bring their evidence that probably pins Thomas Lubanga is very, very important. And therefore, the justice system may be long, may be burdensome, may be very expensive, but it's a necessary evil that we need. It's not something that we can wish away. And maybe to add to that, the fact that this is a creation of states. It's a creation of states that have ratified the statute. Over 121 states have ratified this statute. So it's not something that we can wish away, but for me, what I want to look at is how can we reform it? if it's been the character of the prosecutor, probably, what do we do? And what can we do as civil society, as academics, as experts on this area to improve the system within?
All right, we'll talk about that reform. That's an important
exactly.
point.
But I think that the court is still a very, very necessary instrument in the fight against impunity.
Jimmy, what do you think we need to reform if we want to reform the ICC?
Two things. There are two things we are talking about here. We have the ICC, then we have the state parties. The ICC relies on the cooperation of state parties. For instance, we all aware that in the Rome Statute, there is no provision for the police or the army to enforce arrest warrant. So that means that one thing that is very important is the cooperation of state parties to cooperate so the ICC can do its work. The ICC is a judicial institution with a judicial mandate. That is the limitation. So it cannot function outside the judicial mandate, like for political or otherwise. That is one thing. So we need a lot of cooperation from state parties, from civil society, and from different actors to make the court move forward. I want to state like what the president of the ICC said in the occasion to mark the 10 years anniversary, that what is important now for the court is not to look at the achievement. Most importantly is to look at the challenges and new ideas to move the court forward. This is the thing he made very clear.
Brian, would you tell if we had strong local courts?
Yes, of course, of course. My major problem with the ICC is the problem of micromanagement. Micromanagement of crime. You hear of an electoral dispute in Ivory Coast and immediately indict Laura Gbagbo. And what's the progress of the case? We don't know. You hear of a civil conflict in Libya, and because of interests and the Security Council tells you move, and then you move. And now
a lot of people died in Libya. Systems are being broken down.
I agree, but then what do we have now? Where is
micromanagement?
Where is Saif el-Gaddafi now? Why isn't the ICC trying him right now? You know, and then you have a situation that we all know about in Palestine and Israel, and then the prosecutor says, no, I can't take this on. And then compare the numbers. If we talk about numbers of victims, compare the numbers in Ivory Coast, compare the numbers in Palestine, and then see how the prosecutor chooses who he prosecutes. Then to go beyond that, let's look at the ICTR and Gachacha. You have millions of people, and beyond even justice, you have reconciliation and reconstruction going on in Rwanda. You take Lubanga to the ICC. Does that actually build the local justice system? It doesn't. You give an indictment of Joseph Kony, and then some excited people make a video and it goes viral, and there is a lot of mob justice that lets all go and arrest. Exactly. After that it dies down. And then Kony is still there, and there is no reconstruction in northern Uganda. So is that justice? Does justice mean taking someone into a hotel that you call a prison?
Oh, they live in hotels?
I mean, if you compare that prison to Luzera prison, that's a hotel.
Go on.
And we're talking about African conditions here.
Well, they can argue when they don't get sausages or bacon in the morning at the right temperature.
Yeah, but then what is Kony eating in the bush? Is it bacon? What was Lubanga eating in the bush?
Well, but freedom is an ideal. Sometimes think, you know.
That's to assume, probably maybe to take on what Brian has said in the last piece of the restriction of liberties. For me, when you're imprisoned, what's the most important part is that your liberty is restricted.
Yes.
And liberty is a very fundamental human right. To assume that people should go into prisons that are also torture chambers is, for me, wrong. So whether they're in a good prison is an ideal that we should all work for.
All right.
But also to add to what Brian said is that the court is not a magic wand to all the conflicts that affect Africa, and therefore we cannot assume that it will come in and bring in transformation and change and effective justice. Not at all. What it works for is to have national institutions working, and then the court will only come in when those national institutions are not working, unwilling or unable, like it was in the Ugandan situation. So it's not to assume that the court is micromanaging. I don't think it's micromanaging, but most of the time they're filling in the gap, and they're trying those most responsible, who are just a handful. The rest of the suspects, the rest of the people who are committing crimes are probably being tried or not tried by the national institutions. So what do we do where national institutions have failed? We probably need a global institution to handle those crimes.
Jimmy, is there a possibility of having local courts that actually work in Africa specifically?
Why not? I mean,
well, in Uganda, we have the International Criminal. It's never taken off.
The ICD is operational in Uganda. I mean, perhaps let me give a background to the Ugandan situation. We are all aware Uganda joined the court in 2002. In 2003, Uganda referred the situation in northern Uganda to the court. Then in 2004, the Office of the Prosecutor initiated proceeding investigation in the Ugandan situation, which investigation is still ongoing. And in 2005, the Office of the Prosecutor requested the judges to issue arrest warrant against 5 top LRA commander: Joseph Kony, Vincent Otim, Okoto Diambo, Dominic Ongwen, and Rascal Okwia. In 2007, one of the suspects named on the arrest warrant, Rascal Okwia, was indeed confirmed dead, meaning that the arrest warrant was terminated. Now, as we speak now, 4 arrest warrants are still outstanding against Joseph Kony, Vincent Otim, Dominic Ongwen, and Rascal Okwia. Of course, judicial development is limited here because there has been nothing like an arrest. Yeah? Because without arrest, as I said earlier, the ICC court is not like any other institution. Without a suspect in the courtroom, the court cannot move. So that calls for the cooperation of state parties, Uganda, Kenya, DRC, etc. They must cooperate to have this suspect before court so that the trial is taking off and we see that victims get the justice they deserve. And that also is linked to reparation, because in the ICC, reparation comes at the very last end. I mean, when a guilty verdict is made and the convict is in the cell. So in this case, if there are no trials, there are no arrests, there's even no reparation. However, in the context of the Ugandan situation, we also have the Trust Fund for Victims, a different institution that is also trying to give out what we call interim reparation, maybe like psychosocial, medical rehabilitation and so forth in northern Uganda. This is ongoing because there are things that cannot wait. For instance, if you've been shot and you have a bullet in you can't wait for a trial, like when Kony is not in the court, I mean in the courtroom for trial. This is the thing that is happening in Uganda. However, this situation is still before the court, is active, but there's limited judicial development simply because there's no arrest warrant. I mean, there's no suspect before the court.
Well, listeners, this is Spectrum on Radio 1 tonight. Assessing the international criminal justice system. Is the International Criminal Court meeting the expectations at decade since its inception? Our guest, Mr. Stephen Tumwesigye, Legal Associate on International and Traditional Justice Program at HURINET. Mr. Bwesigye, expert on international law and justice, and Mr. Jimmy Otim, Public Information and Outreach Officer of the ICC in Uganda. You will be able to call in at some stage and contribute to this discussion. Brian, do you think we can have African courts that actually deliver justice? African criminal courts?
I think we can, but we don't have yet. I look at the example of the European Court of Human Rights. The European Court of Human Rights works for Europe. They try different human rights cases. Although it's not a criminal court, but it's an example of a regional institution that works. The problem that we have with our systems is that there is that tendency of states to control the courts. So we have the African court, but as we know, there is no political will to support the court. So the court is lying there idle, just like the East African Court of Justice. You have it there. It's only used when people want to use it for political ends, but there is no will to support the court. If there is that will, then we will have the court, and then we may not need a global justice system, or if we need, then it will be a system of last resort. But as of now, because of our politics and because we do not have leaders that are willing to put themselves to the test, then we don't have the court. But I think if we get out of using the courts for political ends, then we can have a court that can work for, like every other region has a court that works for them.
So Africans could do themselves some justice, redeem some dignity by having an African criminal court that works, but then the fiber doesn't agree with that. They would still not get it to work.
And I think the problem is with us first. If we have the court, if we invest
it's not going to work.
Yes, if we invest in the court.
In other places it works. In Europe it works. Here it won't work. And that's why you have more Africans at the ICC.
I don't think we have more Africans at the ICC because it won't work. I think we have more Africans at the ICC because Africa is a bogey case. Because there is a stereotype that there is a lot of war in Africa.
There is a lot of war in Africa, statistically.
Yes, but there is also a lot of war in Eastern Europe. Kazakhstan, the Kyrgyz are killing each other. There is a lot of war. Oh, Palestine and Israel. I mean, for how many years has Palestine and Israel been at war? For how many years have we seen the Afghanistan conflict? Pakistan, India, Kashmir.
One prolonged conflict is different from many.
But look at the conflicts we're talking about in Africa. Look at Gbagbo and the electoral dispute, and how many months were those? And then you have the prosecutor moving up and down. How many civil society petitions did the prosecutor receive about Iraq? How many? How many did he receive about Ivory Coast? So if tomorrow we have a conflict between Bwesigye and Museveni over an election, you have the prosecutor swinging in action because it's Africa. If you have a case in the courts between Al Gore and George Bush and an electoral dispute, he won't show up.
So there's some racism. Are you alleging there could be racism?
No, it's a stereotype. It's simplifying complex situations. You see the Darfur situation, for instance. You say Arabs are killing Africans, and it's a simple story.
Right.
Everyone agrees with that. You forget about all the other conflicts, even within Africa, by the way, because they are not in the stereotype.
I agree with the mindset that they've fomented. Well, we'll have to go for a break. We'll be back to stay tuned.
So unbelievable, na yatenga vya dala techiwadde ise yadde nakamo bendera waggulu bulaka tuli beautiful yero wakasana kapenga kasupu red brotherhood eyatero wetugatta
Tuchakale with Airtel today and celebrate 50 years of independence. Get up to 100% bonus to call across all networks. That's not all. Stand a chance to win a motorbike daily and a car every week. Simply top up every day. Get up to 100% bonus. Dial star 162 hash. Press yes or okay. Start the 50 years independence celebration of Uganda today with Tuchakale from Airtel.
John, Mike and I will go back a bit. We knew John at the beginning, working for someone else. But he was different. He had vision, saw opportunities. He started working towards his goal, opened his own garage, and worked, learning the hard way. His reputation spread. Trust, consistency, quality. Soon people were coming to him from all parts. He made himself and his whole street prosper, and also help friends, seeing potential in people and helping them on. But John never shouts about all his success. He's just who he is. Special.
So here's to your like John, who make a difference. Who enjoy Now Special, the rich, satisfying taste for the sauce. Now Special.
You've earned it. Not for sale to persons under 18.
Spectrum on Radio 1 FM 90.
We come back on Spectrum tonight. Assessing the international criminal justice system. Is the International Criminal Court meeting the expectations at decades since its inception? Our guest tonight, Mr. Stephen Tumwesigye, Legal Associate on International and Traditional Justice Program at HURINET-U, Uganda. Mr. Bwesigye, Expert on International Law and Justice, and Mr. Jimmy Otim, Public Information and Outreach Officer in Uganda, representing, working for the ICC, that's the International Criminal Court. You will be able to call in and contribute to this discussion. Stephen, again we come back to the core problem. Does the ICC actually stereotype Africa?
See, just say that the court, for instance, some people have argued that the court is an imperialist element and that it targets Africans. For me, that argument is to forget the fact that there are victims in Africa, and therefore who need justice. And it's also to forget the fact that African states were some of the most active states that probably
some of the
most active states
yes,
that led to the ratification and the adoption of the Rome Statute in 1998.
You got adopted this in 2012
and 2002. So as a result, maybe the argument is by African leaders. At that time, they thought that the court was probably going to target rebel groups in their countries, and
they signed quickly.
And they signed quickly.
And it turned out it was against them.
Not necessarily against them, but they thought that they would use it against those leaders. But now the court is targeting a head of state. That, for me, is what the African Union is arguing.
Now they don't like it.
What
happens if they set up an African court? God forbid, some people will say. Nobody will end up in that. The world will be clean. And
like I said during the break, what is the motive of setting up the African court? The African Commission on Human and People's Rights has been existent. It has a huge backlog of cases. Now, how about when you add its jurisdiction, and you add there a criminal jurisdiction.
So cronyism in Africa will take over. In Lilongwe, they were supposed to host the African Union Summit. They said Bashir won't show up here. Then they said, oh, we'll move it because our brother, we love our brother.
Exactly, that's the intention. Why are we setting up this court? Is it to evade the long arm of justice? But also maybe to add to that, these institutions are not out of interruption by African leaders. The SADC Tribunal, which is a membership of over 15 states, the tribunal, the court for the SADC organization, has been closed down after process by Robert Mugabe.
Yes. We know his ways.
So you can say that the court will be out of interruption by African leaders. Probably what we need is a more independent court that will be able to target everyone regardless of their position.
In Africa, it's going to be in Africa. African brotherhood will take over.
Exactly, that's what I'm saying. So the motive of setting up the African
non-interference in other people's internal affairs.
Probably the motive is not that. The motive is different. The motive is to sidestep the long arm of justice. Yeah.
Well, that's interesting. Jimmy, talk to us about the situation in Kenya. The speed at which they move means some of the indictees or the suspects could stand for president, and we could have a Bashir situation.
Thank you, Edmond. The Kenyan situation, we all know, it came to the court as a result of the prosecutor acting pro mutu. In other words, the prosecutor using his discretionary power as provided for in the Rome Statute to initiate proceeding after seeking the authorization from the judges of the ICC after the post-election violence in Kenya. Now, I don't work for the office of the prosecutor. I can't speak for the office of the prosecutor, but we've always heard him saying that he will go for the evidence. As a result of that, that someone were issued against 6 suspects in the Kenyan situation. Now, we are also aware that the trial is supposed to begin next year after the election in April. Yeah,
yes.
That's when the trial starts.
We could have a Sudan situation.
Well, I'm not sure, but...
well, it's a possibility, isn't it? It's not a hypothetical situation. They're having an election in March.
Could be, but like the prosecutor always made it very clear that as the ICC, he will go for the evidence, he's not going to influence the outcome of the election and so forth.
But let's talk about that guy. Why couldn't they do it earlier, so by the time people go into elections, they know who's guilty and who's not?
I think the decision to hold trial is clearly spelled out in the Rome Statute. You know, you look at a lot of context, so I can't say, you know, they do this because of ABCD.
At which they did it.
Also, they were concerned from the Kenyan that, okay, maybe you first wait after election. So all these were put into context.
So politics came into the ambit of justice.
Well, that was the situation that happened. There were discussion that, okay, maybe you first hold on, you know, because...
Was it above board?
Sorry?
Was it above board?
No,
Some people got villas in Spain. Well, Brian, talk to us. Why would they not move it faster?
I think the Kenyan situation is a typical example of the politics of the ICC prosecutor and the states he deals with. Because even look at how he did the indictment. You choose 3 from one political side
and 3
from another political side.
Representative justice.
And then you know some you don't have a lot of evidence, and so you will know some will be free after.
You dropped 2.
You dropped. So it's a political thing. It's stage managed, if we say that. And when you look, and is that justice that we want to support? Is that the justice that victims deserve?
Well, but there must be an exemplary side to it. When you indict, when you indict whatever, when you sentence a defiler, it's not the only one defiling children, but you want to send a message. There's that element in justice.
That's true, but then if you're not considering the gravity of the offenses committed, if you're not considering the level of involvement, but rather considering this tribe, this side, that side, then that's not justice. Because the Rome Statute...
There's too much mathematics.
Exactly. And that's political than legal.
And probably I'd like to add that it's not the prosecutor who decides those matters.
Yeah.
The Rome Statute is very clear that you present these names before the pre-trial chamber, who then make a confirmation as to where these persons... You have presented sufficient evidence for these people to be brought before the court.
Yes.
So for me, it's not theatrics. It's rather a course of justice, which may be long, but we need it. And you see, you cannot ignore the political situation in Kenya. You're indicting heads of political parties. What impact do you create if you rush the process? So for me,
would go for machetes again.
Exactly. So you have to be
tribes.
work as an international prosecutor, you have to also consider the local politics and the local context. For me to think that you can have prosecution and then choose how you want to handle it and then rush it is to forget the very ideals of justice which are formed within societal values.
Is there such a thing as blind justice? He was trying to define something close to that.
Blind justice?
Yeah.
Which is then what?
Pedantic justice, you judge according, you are defining something close to that.
Yeah, because I think
according to the letter, forget about the spirit.
Yeah, no, because look, if we are saying you killed people, you're responsible, we have the evidence. I mean, to speak in the Ocampo sense, we have the evidence, you know, we have witnesses, and we are sure that you did this. And then you come before the pretrial chamber and they tell you, proceed. I mean, then what are you waiting for? If you have, because you see, to speak for the accused, because they also have rights,
yes,
presumption of innocence.
Yes.
To speak for the accused, you even when you still have the presumption of innocence, the fact is that you're accused, and that disadvantages you. And if you have all the evidence, then what are you waiting for? If you have all the evidence,
what arguments do you think they would have had in this case, delaying it until April after the poll?
I think that's the point. The fact that there is a lot of politics involved, and you have the Kenyan parliament making decisions, resolutions, and the ICC listens to that. Because if you're doing justice, yes, you need to take care of the politics, but do the politics affect your decisions?
You should not color it too much.
Because if you're talking about the victims, are the victims the ones telling the court to hold on the process? No. I don't know who is speaking for the victims.
Who did this?
That's the point. It's still the politicians.
That is to think that the court works on the process in Kenya. It depends. It's to argue that the court then will work on what is taking place in Kenya, but that's not very true. What is taking place is that there are processes within the court system. The prosecutor makes a request, which he did before the pre-trial chamber. The pre-trial chamber confirmed 4 of the 6 people who are wanted by the court, and then the process has now proceeded to the trial stage. Now, for me, that's not theatrics, that's not politics. That's
but the time lag.
The time lag is before it is allowed for in the Rome Statute.
They're stretching the boundary.
Coming here, Steve, you remember the situation in Kenya actually was referred to the court by the civil society, them writing. So again, they were a bit concerned that, okay, maybe the trial should start after the election, because you know the dynamics in civil society, because they are also important players in this fight in the impunity. Now, in Kenya, the tribal thing is complex. I was in Kenya, I worked in Kenya like for a couple of months doing outreach.
Yes.
It is not like Uganda. Yeah? When you go to some community, they'll say, oh, these people did A, B, C, D. These people did A, B, C. So the civil society were concerned, okay, maybe the trial and other processes should start after the election, to leave the national processes also to take it on course. And I think that was healthy. That's something that is healthy, because you are also mindful of the impact your work will create in a situation where you are working.
Right. So how should we reform the ICC, Brian?
No, my again, to just make a small comment. Then again, we go back to the ICC promising more than it can deliver. If you promise this and then later back down because of what you say is other things, then you've promised more than you can deliver. Now, I think the ICC can be reformed. One, listen to the victims. We civil society says the victims want this, but it's such deeper. Do the victims actually want what the civil society is saying they want?
Why did you mistrust the civil society?
It's not that I mistrust the civil society, but we know as a matter of fact that civil society organizations are founded by people that have their own agendas. These are not the victims. The people that are amputated.
Well, but what medium do you use? You have the civil society. Can you get better than that?
I think
communities. How do you
let's face it. Who is in the civil society? It is us, the middle class. It is us who are educated.
Well, the middle class translate things for the complex things to the people. We know it from Animal Farm and other places.
Yeah, but then we cannot ignore the classism of our society. So, if I deviate from the Kenyan situation and go to the Ugandan situation, for instance, how many people would be interested in having trial justice? How many people are interested in the Matoput? Without even government support, we have had cases of Matoput processes going on. But reconciliation, because what is justice? Justice is not a judge in a wig, and even when the weather is too hot and the person is sweating, that is not necessarily justice. Justice is what the people think is justice, and if the people think that reconciliation and Matoput and those systems is justice, then it is justice if we listen to the victims. But because we are educated,
it's cutting off a man's head in front of in a football stadium.
Yeah, but of course we know the African concept of justice is not that. We know that African concept of justice is restoration. It is you have wronged, but you can be welcomed back to the community.
You also know about the matters.
Yes, but again, that's a different matter altogether, because I'm looking at us, the civil society, pushing a certain agenda that is not necessarily in line with what the victims are saying. Because if it wasn't that, we wouldn't have many Congolese that are talking about the Lubanga issue and are saying it is unfair, that because we are speaking, but we are not necessarily speaking for them. In the northern Uganda, for instance, it would be more comfortable if the Trust Fund for Victims was doing more work than Ocampo appearing in the sleek Kony 2012 video, because that is listening and taking care of the concerns of the victims. You're not going to spend billions of money trying a few people. You see the accused flying. I mean, how many people need food? How many people in camps in Kenya? How much money are we spending on these people? How much money did the ICC system spend to give legal aid to Lubanga? And how many people would that money help in the Congo?
For us, of questions here, Jimmy, is the prosecutor's office, we know there's a woman now, Fatou Bensouda, I believe, is it solid? Is it watertight? Because yesterday William Ruto repeated that Raila Odinga and Mwai Kibaki were left out because it was better to leave them out, that they could have been indicted.
Edmond and listeners out there, the office of the prosecutor is fully represented. There are many staff, but as I said, I work for the registry.
You are the same people.
Yes, but let me explain here. I work for a different section of the court, that is the registry, which does most of the
status and presence of
non-judicial aspect of the court. But however, I can state things that are official from the office of the prosecutor. Like Ocampo has always said, he goes where the evidence leads him.
He's no longer there, he's going to judge.
He's gone, but Fatou Bensouda has come in.
Yeah. Well, listeners, this is Spectrum on Radio 1. Talk to us tonight. Assessing the international criminal justice system, is the International Criminal Court meeting the expectations? I take it since it's inception. You can call in now. Our numbers 0414348111, 0312260390, 0312261390. When you call in, please tell us your name and where you are calling from. Stephen, let's talk about the Ugandan Criminal Court Division. How is it faring? Can you give us a profile of it and how it's been able to perform since it was started?
Well, in Uganda we have what we call the International Crimes Division of the High Court, which is a division specifically trying international crimes, probably those that are similar to those that are triable by the International Criminal Court. And this is in line with the principle of complementarity, which states that as long as states are able and willing and have national institutions, then the court will not come in. Well, the court has had one trial, which was not a success, the Thomas Coelho trial, essentially because of the provisions of the Amnesty Act. Which Amnesty Act has since now, part 2 of that act has since lapsed. But to mention that, well, the court now needs to be reformed and to have more provisions that are probably proactive and progressive. Provisions like victim participation, witness protections, provisions that are probably in the Rome Statute, but we may want to bring them home and to make probably a broader international justice system that is also localized.
Okay, Spectrum, hello. Yes, sir, your name?
Jimmy.
Yes, Jimmy. Okay, Spectrum, hello. Okay, let's get back here. Stephen, talk to us.
I was also adding that there's a need, like Brian was saying, to note that the court is not a magic wand. Trials and
prosecutions spends €5 billion. It should be able to deliver, really.
Trials and prosecutions may not bring about transformation of societies. So what is now happening within probably the justice law and order sector is to have what they call a transitional justice bill that will then bring in issues to do with national reconciliation, probably to address the many underlying governance problems that we have in this country, questions of truth-telling.
Mitigation rather than litigation.
Than litigation. So because essentially the justice system, like this gentleman points out, our courts are, the processes are long, the process may be compromised. It's on record that Transparency International has said that the judiciary is one of the...
Spectrum, hello? Hello? You're live on Spectrum, my friend. Your name? Okay. Alright, you can still call in. Alright, Stephen, let's go.
Yep, so for me, it's not a question of the court being a magic wand. There are duties that the state has, for instance, in Uganda, to reform the lives of people in northern Uganda who are affected by the conflict in form of reparations, because they have duty to protect those citizens. And therefore, for me to put that whole burden on a judicial institution is wrong. Rather, we need to reform our local institutions, the courts, the traditional justice mechanisms.
All right, Spectrum, hello?
Yes, good morning, good evening.
Good evening, your name?
My name is Idili Waliareva.
Idili, you're welcome.
Thank you for...
Before I've had men who arrive at a polling station with the guns in one hand and sticks in another. How should we treat those ones? They have guns on one hand and sticks in another, buttons or whatever, and they're not police officers. They're in rare clothes and they look like guns. Some people think it could lead to an uncoordinated movement of troops. It happened in Nakulaye many years ago in the 60s. Troops of the same army shooting at each other because they were uncoordinated. Brian, talk to us about this, Thomas, as you respond to these concerns. Of course, Jimmy didn't give us the details on what he thought about Matthias Nsubga. He didn't quite elaborate on it. But talk about the Thomas Coelho issue as you respond to these issues as well. How did we fail in that particular case?
I think, again, as Stephen said before, the thinking of African states that the court is going to be there just to help them get rid of some rebels is what leads to the failure of national institutions, because there's no will to support the national institutions. They think refer the case to the ICC, full stop. They don't think about what happens on the national level, because if you look at the progress,
I think it's a magic wand, like Stephen was saying.
For them, it's a pawn in a chess game.
Yes.
The ICC is one way of, if you don't defeat the rebel politically or on the battlefront, use the ICC. Simple. Cooperate when it suits you. Don't cooperate when it doesn't suit you. And that's why you don't have national institutions. Because if they were serious about the ICC system, we would have a national system. We would have everything in line. And as we know, the roots of the International Crimes Division are in the Juba peace talks. They were not because of the ICC treaty. It was because of the Juba peace talks. All this that came, the ICC bill and that was later passed, was after the Juba peace talks. So you see, it's still political. It's still governance. It's still the resolution of conflicts. And that's why, for me, I think we better concentrate on the governance issues and setting in place national institutions. Now, if you look at the ICC Act, how could, and the Constitutional Court decision that actually led to the failure of the trial, you realize that we are not moving we are not at the same step. You have the judiciary and the parliament that are moving in another step, where the civil society is pushing for end to impunity, but amnesty is impunity by another name.
What do you mean? Well, of course it is. You forgive someone who committed crimes.
And if impunity means punishing someone for committing a crime, if the lack of impunity means punishing someone for committing a crime and you're forgiving them, then that means amnesty is impunity. And this is an act of parliament. And the Constitutional Court says, proceed the act. You know, so it shows the lack of political will and how the African governments, even when we are quoting the figures and we're saying 121 states, the largest group of signatories is African. The African states were not looking at this as a way of ending impunity. They were looking for aid because it was to some state
pleasing Ganko.
Where they had it probably.
Exactly. You know, sometimes we're even represented by mercenary diplomats rather than
diplomats.
Yes, rather than our real ministers of foreign affairs. Some who do not even understand what is going on. So
I think that's unfair to our colleagues who work probably in the ministries that are available. I think that these guys knew what they were signing. They knew what they were signing.
They wanted aid to come.
They knew their intention, probably to prosecute those people who are fighting against them. But now the court has turned and said, we are a judicial institution established to fight impunity, and we'll go against anyone who commits crimes. Yes. And now, so they are saying, why then we need this court? Now they are trying to say that, you know, we have to undermine this court because it's not serving our purposes. So for me, that's where the problem is, and that's where the whole argument about the court being neo-colonial is perpetrated by African governments. Okay, the African Union, not even African.
They're trying to undermine it because the
African people
turn out to be what they expect.
Essentially because of the al-Bashir arrest warrant. Essentially,
they were very disappointed in that. How do you indict a whole head of state sitting, moreover?
Because the provision of the statute is very clear that he's saying.
But talk to us about this governance and national institution. What exactly do you mean? You say you spoke about the legislature moving in one direction and the justice. You didn't mention the executive. Talk to us about that.
Yeah, because I'll give you the example of Mato Put. You have a system that the people, the grassroots are supporting. They are involved in. There is that video that was on Al Jazeera, the witness program on the Al Jazeera, where two people that had been fighting for Joseph Kona's child soldiers came back and underwent the Mato Put process. Government is out of it. No government funding, no government cooperation.
Yes.
Grassroots people. Our dear civil society, out of it. ICC, out of it. People solving their problem locally. Even us, even people in the media. I'm talking about Al Jazeera, but look, where was it in News Vision? Where was it in the Monitor? So I think these are the concerns that we need to solve, because you could arrest Kony today, but there will be another Kony tomorrow if these issues are not resolved. And that's why, in my view, the people, the grassroots, prefer to solve these problems themselves. It's not because they're supporting impunity, but because the concept of justice is not the concept. It's a little bit different. And if we don't realize that, and for me, that's why the Rwanda example suffices. You have Gachacha that involves everyone in the community.
Sitting on the grass.
Sitting on the grass. Spending little money and solving problems.
No budget.
Cleaning up the punishment, clean up the community. Kigali is now the cleanest city in Africa. Look at the ICTR.
Increasingly, Edmond and Brian points it out clearly that now there's a trend that we need to move out from trials, prosecutions, to what now is called transitional justice. And that you have transformative justice systems, which bring in, for instance, you have national reconciliation, you probably have amnesties where you forgive some people but bring about peace, you have reparations to communities that were affected by the conflict, you have probably community healing processes, you build memorials to reform societies, and then trials come in probably at first or at the last end to handle those who are most responsible, and as a deterrent mechanism, prevent future commission of crimes. But the purpose should be a wholesome process and not just a trial, a conviction, and then that's it, because the underlying causes of conflict, if they're not addressed, then they come back. We come back to square one. So for me, what we should now be advocating for, and which we consistently talking about now, is transitional justice, and we're trying to enter into the justice and the system sector to have those processes implemented. So transitional justice is more broader than just international justice, which is really restricted to trials.
Right. Yeah. Well, we have to go. Thank you very much, dear guest. Very insightful discussion had tonight. Mr. Tumwesigye, Legal Associate on International and Transitional Justice Program at HURINET Uganda. Thank you for coming to Spectrum. Mr. Bwesigye is expert on international law and justice. He looks very, very young to me, and but he's really got his stuff, you know. Mr. Jimmy Otim, Public Information and Outreach Officer in Uganda at the ICC. Thank you for tuning in. I've been your host, Edmond. This is Spectrum. We'll be back tomorrow. Up next is the news in English.
Everybody wins. Everybody wins. Everybody wins. Everybody wins. Simply join MTN.